Colin O'Keefe here for LXBN TV. In news that's making a lot of headlines, Apple was ordered to pay $532.9 million after a federal jury in Texas found that its iTunes software infringed on 3 patents. Joining me to explain exactly what happened in the case and its impact is someone who works in this space. It's Chicago attorney Rich Beem of Beem Patent Law and author on the blog Beem on Patents. Rich, first off, the question a lot of people are going to ask here is, how is this justified? How are these patents, owned by a company that just owns them and isn't doing anything with them? How are they worth more than $500 million in this instance?
The sales of Apple on iTunes and software is reported at $18 billion in its last fiscal year. So $500 million represents about 2.5% of the sales of software through iTunes. So it could be justified on that basis. There's no doubt we'll attack the amount of the award on appeal. But there is support for the award, there's rationale for it. And as for the fact of the smart flash people not practicing the patent, it is not a requirement of the patent law that the patent owner should practice the patent itself. There are barriers to entry in this business. Smart flash started into it early, about 1999, long before iTunes, long before Apple was doing anything in the way of apps. So they were an early entrant into the market, and their contention is that they disclosed this technology to one of the people who's now at Apple in charge of this technology. So there is a connection between the smart flash people and their early development prior to Apple's adoption of the technology.
I see, because of course when it comes to these types of instances, everyone's worried that these non-practicing entities are kind of playing a game of gotcha, but it's interesting that there was, some, whether warning or knowledge or that type of thing, going back a number of years. So of course, when we take a look at these patents, based on what I'm reading, these are not narrow patents, and Apple of course has paid its due here in some regard, but how much is this going to impact what other technology companies are doing in this space? Because again, these seem like broader, more far-reaching patents when it comes to electronic payment and that type of thing.
The patent owners, Smart Flash, have sued other companies. They have sued Samsung and Google and also Amazon. This again goes to the necessity of a certain amount of size in this space. So Apple, Samsung, and Google are all active in smartphones. In addition, Google is active in electronic commerce, and of course, Amazon is very active in electronic commerce. Amazon's also getting into smartphones and apps. So these other companies might very well be called on to pay tribute to these patents. Also, as far as Apple paying damages, they have not yet written a check, and they're not likely to do so for quite some time. It's typical that a defendant that has been adjudicated as an infringer and liable for damages under a jury verdict, there will be motion practice in the district court, and then there will be an inevitable appeal to the federal circuit. The courts have been cutting back on damages. So Apple certainly is going to do everything that it can to try to get the damages award reduced on appeal.
Absolutely. It's going to be interesting to watch. This is far from the end of the story, not just because they're probably going to go after other companies, but because there's still a long way to go in the fight just between this company here and then Apple themselves. This is almost just with the verdict that was handed down, really just the beginning of the story almost. So it's going to be interesting to watch, and I'm sure we'll be able to track it with your insight as well. Once again, that was Rich Beem of Beem Patent Law. For more of his insight on patent law and other stories that take place in this space, be sure to visit beamonpatents.com. Thank you for joining me today, Rich.
Thank you, Colin.